I must give this disclaimer. So any views that I express here are entirely my own. They are not the views or opinions of the Office of the Director of Public Prosecutions. And just in case somebody may think so, no, they are not the views or opinions of Ms. Paula Llewellyn, who is the Director of Public Prosecutions. And neither are they the opinions of the JBU Social Issues Commission. So I'm going to start out, but I really want to do the presentation in a way in which I think I will allow you to make up your own mind. So I'm going to try as much as possible not to inflict my views upon you unless I think I can't escape it, and not really leave you to form the view. So I'm going to start out first with a situation. Why is the screen not moving? Yes. The case of Danisha Marie Beckwith. Now, I have made up these names, and I am hoping that there is nobody in the congregation, in the audience, who has a similar name or is related to anybody with this name or any of the names that I use here. I really want to frame it to show that the issues surrounding abortion are not as clear-cut as we sometimes see coming from out of the United States. This example may be a bit extreme, but it can happen and has happened in the past. And I will perhaps take the first three responses in the chat, and if it's broadcast on YouTube, the first three responses on YouTube. So I'm going to ask those who are monitoring both platforms to give me the responses, but let me read. Danisha Marie Beckwith is a 16-year-old girl with big dreams. She wants to be the female Jamaican equivalent of Elon Musk, a business tycoon. One day, while walking home from school, the Windsor Castle Academy for Girls, she was hit by a drunk driver. She suffered brain damage and is in a permanent coma and is on life support. The doctors at the Dorcas Lazarus Memorial Hospital have tried every kind of therapy and experimental therapies, hoping to return her to a state of awareness without success. Her parents are highly involved members of the Mountain Heights Baptist Church, and Danisha was a very involved member of the Sunday School and the Youth Fellowship. After being in the hospital for 6 months, the doctors have informed the parents that Danisha is pregnant and that the pregnancy is about 1 month old. They theorize someone, possibly a staff member, came onto the ward and had sexual intercourse with Danisha in her comatose state. The doctors advise that the pregnancy is a danger to Danisha's life, and if the pregnancy continues to term, it will kill Danisha, and there is no guarantee that the child will be born alive or without congenital conditions. The doctors are asking for a decision to be made. Danisha's father says what has happened to Danisha is a sin in the eyes of the Lord, and God could not and would not allow the fruits of the illicit conception to be brought to term. So he's saying to the doctors, terminate the pregnancy. Danisha's mother says, no, child did not ask to come into the world, and she serves a miracle-making and wonder-working God and tells the doctor, save my daughter and my grandchild. No, and Reverend Dick, I'm going to excuse you from this. You are their pastor. How do you advise? So I'll take the first three responses in the chat. Don't take too long to think, because remember, I don't have much time to. So yes, those who are monitoring the chat, has anybody responded? Anyone?
No response.
No response. All right, we'll move on and then come back to it. I don't want to put my views here. So, or is anybody online who wishes just briefly to unmute and give their view? No one? People, are you still there? I'm feeling lonely.
No takers.
No takers. All right, we will perhaps come back to that. But I am just showing that sometimes decisions around abortion are not as clear-cut as you see it represented in the United States. So let me start with, how did this law come to be? So in 1864, in Spanish Town, and you'll recognize that building there as the present Parish Council building. Well, before that, it used to be the old House of Assembly. This is where the precursor of parliaments used to sit before Kingston became the capital in 1872. 150 years of that this year, by the way. So in 1864, the Jamaican House of Assembly enacted the Offences Against the Person Act. And the Offences Against the Person Act is still in existence today. It is still part of the law book, on the law books of Jamaica. And I want to bring to your attention section 72 and 73, which I will give you the provisions of later. But section 72, the law really prohibits a miscarriage. And then section 7, or using instruments to procure an abortion. And then section 73 charges using substances to procure an abortion. So from 1864 to 1975, 111 years. So in January 1975, and this is why it is called, the title is the 40-year project, the then Minister of Health, the Honorable Kenneth McNeil, Dr. Kenneth McNeil, because he was a medical doctor, proposed changes to the law governing abortion. So independent Jamaica has been having this discussion from 1975. It is now 47 years later, and we are still having this discussion. So out of that initiative, a fertility management unit was established at the Glen Vincent Clinic, where it was alleged that abortions were conducted. And it's interesting with that, because if that is so, it means that the state and the society had reached some kind of consensus and agreement around it. If you could have this clinic, it was performing abortions, and no doctor was being arrested, no woman was being arrested, nobody was being brought before the courts and so on. Again, a difference between what happens in the United States and what happened out here. Eventually, the Glen Vincent Clinic was closed in the 1990s due to lack of funding and inadequate staffing. I am told that it has reopened, but perhaps with a different mandate. So when Dr. McNeil came before the Parliament, he proposed these steps, that the amendment to the Offences Against the Persons Act should make it clear when an abortion would be lawful in Jamaica. So he was saying, all right, because right now, an abortion, the prohibition against abortion in Jamaica is absolute for the most part. He also said the law should create exceptions, that rape, carnal abuse, and incest, if you got pregnant in those circumstances, it would be lawful to terminate the pregnancy. And I don't know how many of you, I think either in August or July, saw a newspaper article in the Gleaner in which a father was found guilty in the Westmoreland Circuit Court for incest, and it turns out he made his daughter pregnant, and the daughter was delivered of the child. So this is a circumstance where if this happens, there should be a lawful exception. And then he went on to add there should be certain things. For example, a teenager getting pregnant either in whatever circumstances, rape, incest, or a case in which she's pregnant for another teenager. Whether that should also be a lawful exception. So that was put out there from 1975. Those were the proposals. You can see then the fact that we're still having this discussion, that the then government did not act on it. I mean, Dr. McNeil's government would have lost power in 1980. The successor government shelved it. When Mr. McNeil's party came back in 89, it was never proceeded with, and it has remained in that way. So, and then between 1990 and 1991, the Ministry of Health, without making any changes to the law, outlined certain criteria for determination of pregnancies at the Victoria Jubilee Hospital. So what we have is that instead of confronting the law head on, we are working, policymakers are working around the law. And it seems that they have some kind of social consensus in Jamaica that allows them to be working around the law without any great criticism or vilification. It could be that the government has sensed the mood of the people and said, well, boy, really not into scraping up and prosecuting and arresting people in these kinds of situations and so on. And the truth is, when you look at the numbers, there aren't many abortion cases that come to light. I mean, I have been at the office of the Director of Public Prosecution since 2004. And I think in all my years there, I have really only seen 2 abortion cases. That is just me, 2. It could have been more, but I am only really aware of 2 in my years at the DPP's office since 2004. So what happens is that abortion is really an issue which generates a lot of light, generates a lot of heat, a lot of people speaking about the law and how the law should be enforced, but really and truly, the law, really not much cases in relation to the law. Then Minister of Health, Horace Daly, formed an abortion policy research group, which I refer to as APRAG, which consisted of doctors, nurses, and the clergy, and that they should consult and produce a report, which they did. And by the time that report was published and sent to Parliament, the government had changed. So Mr. Dudley was no longer the Minister of Health. It was then the Honorable Rudyard Spencer. The report was tabled in Parliament by Mr. Spencer. And then after that, nothing. Not a peep. We didn't hear Welsh Boy law was going to be drafted. Nothing just happened. It seemed to have gone into file 13. And then it came back on the policy agenda when then government backbencher Juliet Cuthbert Flynn moved a resolution in the House, a private member's motion, asking the government, the Parliament, to reconsider Section 72 and 73 of the Offences Against the Persons Act. And her proposal is that it should be decriminalized. So again, the proposals went before a committee of the House of Representatives, a joint select committee, that was chaired by then opposition member, the Reverend Ronald Thwaites, a deacon of the Roman Catholic Church, a faith community with a well-known and articulate opposition to abortion. And the report was produced. And that report lies somewhere in the bowels of Parliament, meaning that perhaps if you want to see it, you will have to call up to Gordon House, speak to the parliamentary librarian, and ask if you can get a copy of the report that was produced by the Human Resource and Social Development Committee of the House of Representatives. It certainly has not been published on the House of Representatives website. So I assume that since the report said the report is in existence, it is somewhere in Parliament. But despite all the debates that has been going on, nobody has asked for the report to be made public. So we still don't know what that committee thought about the abortion issue. And we still don't know why it hasn't been brought before the full House of Representatives and the Senate to be debated. So we don't know what the position of the committee is or was. And so we have had some news headlines. Cuthbert Flynn wanted Jamaica to take a more progressive line following Argentina, and we will look a little bit on Argentina later in this presentation. And then I think it is the Bishop of the Power of Faith Ministries, called on the Prime Minister to declare a position on abortion. He came out stridently saying, look here, Prime Minister, say whether you are for or against it, but you can't continue to ignore the issue much longer. And I have tried to put a table of countries that legalize abortion. And I have tried to put from the earliest come down to the latest. So you will notice, for those of you who are my age and older, that the first country to do so was a country then called the Union of Soviet Socialist Republics, now Russia. Was the first country to do so in 1919. That's 2 years after the Russian Revolution brought the communists into power. And then you notice that there was no action on the international front until Germany, and I've qualified it, Nazi Germany, and Iceland in the 1930s. And Germany's own is of note because that was really for non-Aryan babies. So the children that did not fit into the German ideology of racial superiority, then, you know, those children could be aborted. First Caribbean country was Cuba. Then the country from whom we have inherited our abortion law, the United Kingdom, decriminalized it way back in the 1960s. So we still have their old version, but they have moved past it. And this is a thing that you find in former colonies, that we sometimes hold on to the very old laws which the mother country has either repealed or modernized or varied, and no longer bears any resemblance to what it was in the past. So British people may be shocked that we still have a law that goes back to the 1860s, while they tried a thing from the 1960s and they have amended it since. The United States did so in 1973 across the board in the entire United States with the Supreme Court decision in Roe against Wade. Now, I have put that it was revoked in 2022, but that's not entirely correct. What has happened is that the United States Supreme Court has declared that there is no constitutional right to an abortion, and they have thrown the issue back to the states. So each individual state is to decide their mind how they are to approach the whole issue. It seems kind of messy to me, but this is the way how their system works. I want to bring to your attention two other countries, Barbados and Guyana. These are the only English-speaking Caribbean territories which have laws dealing with the termination of pregnancies. If you look elsewhere in the English-speaking Caribbean, their laws resemble our section 72 and 73. And many of them were also passed in the 19th century, in the mid to late 19th century. But Barbados and Guyana have moved away from that. And they actually have a legislative regime which allows for the termination of pregnancies. And the last two countries that I want to bring to your attention is Ireland and Argentina. Why do I bring them? Because these are two heavily Catholic countries. In fact, Ireland was more, it has been said, is more Catholic than Rome. And they had a referendum in which the people of Ireland overwhelmingly, 2/3 of the voters, voted to legalize abortion. Argentina is a country from where the Pope comes from, and they had a vote in which abortion was legalized. So that's the world at a glance, and you can say, you can form the view as to where Jamaica fits in the world. So why were laws against abortion passed? Why do we have laws against? So legal historians have come to these three main views as to why you have laws against abortion. One, it was to regulate sexual morality. So it really was to enforce, one, abstinence, and two, you really ought to have children in wedlock. So that's one of the first reasons. The second one was to regulate it as a medical procedure, because, and if you figure out that this is an issue that has been going on from ancient Egypt, in which you do have papyruses showing how to terminate a pregnancy. Anybody with a little knowledge was terminating pregnancies. Any midwife with a little knowledge of herbs was terminating pregnancies. And in those days, coming from way back in ancient times, coming through medieval times and so on, this was a life-threatening procedure. Many women died from it. So this was also an issue. So it was to regulate as a medical practice, as a medical procedure. And the third is that the state, and when we speak about the state here, we're talking about the government, has an interest in protecting prenatal life. And that is based on the fact that when the law in this, when the law in general was being developed and codified, a lot of it was based on canon or church law. And when the law of abortion was being developed, it was being developed around the position that, well, you know, you're dealing with a soul. Although it seems to me that religious teaching in this area was divided as to, one, whether upon conception you had a soul, or two, you could actually do the procedure before the fetus quickened. And quickening meant in those ancient times, and I think it's still used in normal medical terminology, before the woman could feel the fetus in her stomach. I am told it might sometimes manifest itself as gas or into movements or bubbling or whatever. And usually it's like about in the 16th week of pregnancy and so on. So you had a view, human being, upon conception, once the sperm united with the ova, or you could do the procedure, but you had to do it before the fetus quickened, before the woman could feel the child in her womb. So those were the three main reasons why you had the laws. So now, you've heard me speak about these laws. You've heard me mention Section 72 and 73. But what does Section 72 and 73 say? Let's start with Section 72, because Section 72 is the graver of the two provisions. Every woman being with child who with intent to procure her own miscarriage shall lawfully administer to herself or any poison or other noxious thing, or shall unlawfully use an instrument or other means whatsoever with intent to procure the miscarriage, whether she be or be not with child, or shall cause to be administered to her, shall be guilty of an offense and liable to be imprisoned for life with or without hard labor. So section 72 is the one that says life imprisonment for abortion. If you use a drug, if you use an instrument, or by other means whatsoever. So you sometimes do have, and I apologize if I offend some delicate sensibilities here. You do have some men who, when they think the woman is pregnant with another man's child and they think they have been cheated on, who decide that they will beat the child out of the woman's belly. And that happens, and you produce a dead child and the child dies with it. That's the other kind of means that they are speaking about in getting the abortion. So let us break down section 72. So I try to break it down into its component parts, because as you can see, in 1864, when laws were being drafted, punctuation was a foreign concept, and also paragraphing. So let us break it down into its constituent parts. So the first part here, administering a poison or noxious thing with intent to cause a miscarriage. So what this is saying, if you give the drug, you give the person the drug knowing that it is going to be used to cause the abortion, or the person takes the drug knowing that they are trying to induce an abortion or miscarriage. And the other part is using an instrument to procure the miscarriage. And the intention must be the same. So what the law is saying, it's not enough to say that she took the drug. It's not enough to say that she used the instrument or this instrument was used on her. The law is saying you must also prove that when the drug was taken or when the instrument was used, it was used for the purpose to procure the miscarriage. So, who can be charged? The pregnant woman who seeks to procure her own miscarriage can be charged, or any person who helps her. And the usual cases, I think, that have come up in Jamaica, it's usually the other person is usually a parent, and a pregnant woman is usually a child, and it's those cases that I have seen come to court. And then, please note, it is under this provision that doctors and nurses can be charged. But when we come to look at how the law has evolved in this area, well, you will discover it's not very easy to charge a doctor or a nurse. But so far, these are the provisions. So the first one, let me go back. The first part of it is the thing you use to procure the abortion, the drug or the tool. The second part is who can be charged for it. And the third is, well, imprisonment for life if you are found guilty. And it should be noted, especially if there are nurses in the audience here, that the nurse can't say she was acting under instruction of the doctor or that she was acting under superior orders. That would not be a valid defense in court. So, what is it then that my office, myself, if I got this case to prosecute, what is it that I must prove? I must prove that she administered to herself or to another person the poison. I must also prove that the substance was poisonous, or it would have the effect of causing the pregnancy to be lost. So I can prove that the subject was noxious just by the effect. So even if it's not fatal, if it does induce an abortion, I have already proven part of the evidence already. The second thing is I say again, I need to prove the intent. So as a senior prosecutor, if I got a file with this, I would also have to prove that when the drug was taken or when the tool was used, that the intention at the time it was taken or used was to procure the miscarriage. And where administered must prove that she was pregnant at the time. And where the poison is administered by, so the pregnant woman, if I'm dealing with a pregnant woman who has taken it, then I need to prove also that she was pregnant. So usually, because a lot of these abortions go awry, I usually will get a medical certificate by the doctors at the hospital who will speak about, well, they were the fruits of the conception, or the womb, it was in such a state that it was consistent with carrying a pregnancy of so much weeks, and so on. Where a person is helping another to do the abortion, in this case, they must have the view that the person they are helping is pregnant, even if that person is actual fact not pregnant. Their period may have been late. So all I need to know is that if I'm getting somebody who is aiding and abetting, or is helping out a situation, or who believes that they're a good Samaritan in a situation, it is enough for that good Samaritan, that helper, that aid and abetter believes the person is pregnant. And 5, as I said, the guilty mind, you must prove the intention. Again, that was, I did for a drug, it's the same thing in relation to the tool used to procure the abortion. Use the instrument, was utilized, administered with the intent to cause a miscarriage. That also, whereas a pregnant woman who has used the instrument, she must, the prosecution must prove that she was pregnant and not that she believed herself to be pregnant. Whereas an aider and abetter, a helper or a procurer helping this pregnant woman, it is enough that they believe that she was pregnant. So you see that the threshold is lower. The threshold is lower for the aider and abetter than for the person actually doing it to themselves. This is the way how the law is flexible to catch both parties. And the intent, meaning that we need to prove the guilty mind. And you've heard me use the word procure. The Court of Appeal of Jamaica has defined procure to mean obtained by some effort or means, bring about by scheming or plotting, cause to happen or be done, or prevail upon to do something indicates. So the meaning of procure is wide. And anybody who falls within a category, if you're helping somebody to do an abortion, well, can fall within any of these 4 meanings. Let's come now to section 73. Before I move on to section 73, does anybody have any question or comment that they wish to make at that time? At this time.
Right. Mr. Taylor, I'm just wondering, how would the case have come to public prosecution's office in the first place?
All right, so the usual way it comes is that the hospitals usually report it to the police, and then the police start an investigation, and then the file comes, after the investigation is completed, the file comes to us to prosecute the matter. So you will find, and especially hospitals have a duty, well, they have a legal duty if the person that comes before them would they terminate the pregnancy is a child, because they're a prescribed person under the child. The doctor is a prescribed person, the Child Care and Protection Act. So if a pregnant child comes there, or a pregnant or a child suffering the results of an abortion gone bad, the doctor will usually report it. And you will find that people who come there and the doctor suspect this is a criminal offense that has been committed, they will usually report it to the police. So with gunshot wounds, doctors may report it and say, well, you know, we have here somebody who was shot. You might want to come and see if you can wish to speak to him. And you know, at least KP, where KPH and Victoria Jubilee share the same grounds, there's actually a police post on the grounds of that hospital. Any other question? Before I move on? Or any comments?
I don't want to be the one talking too much, but I was just thinking that in the 1970s, when you talked about that situation with Glenn Vincent health clinic, I happen to know at the time a nurse who worked at, and what she told me, what happened was that they would have a fair number of students that would come to the clinic, and that what they were supposed to be doing was to counsel them and walk them through the pregnancy, because at the end of the day, they were trying to find persons who would adopt the newborns. And in fact, the person that I know actually adopted one of them. So I know they also had another agenda. I don't know if they had that agenda of doing abortions, but I do know that they really did try to work with the students that came in to help them to take that pregnancy to full term and then to find a family to adopt the child, even while they were pregnant. So they would link the children, the students with the family that would be interested and to work that, you know, that whole situation through. So I think there was something else going on there as well.
Well, recall, you know, that, well, one, if you look at the slide that I've put, it is alleged that abortions used to be done there. Right. I made sure to pick my word carefully. But the government at the time did establish what they called, as I said before, a fertility management unit.
Yes.
At the clinic. So it could, the duties of that unit could be wide. It could have included counseling, or it could be, as some people have alleged, that it could have also included abortions. But the use of fertility management unit means that there was a wide ambit given to the doctors and nurses there, how to deal with each individual case that came there. So I'm not saying, I'm only saying it is alleged that abortions were done there. I'm not declaring it as a fact.
Okay. And there is someone in the chat who is asking about the role of the pastor. Find out at what stage of the pregnancy it would be life-threatening and the possibility of taking the baby at a point where it is able to survive. Also getting a second option. Yeah.
I think this person, thank you, was dealing with the case situation that I presented at the beginning. Okay. Thank you for your comment. You know, for a while I thought that nobody was going to participate in relation to it. Thank you for your comment. So we have seen that if this person was the pastor, that they would try to do more investigation. Although, please be reminded though that in this situation, you know, they don't really have much time. The doctors are saying if the pregnancy goes on long, it endangers the life of the girl. So decisions will have to be made. But it would be the duty of the pastor to counsel them through it. So section 73, let me go back. So section 73 now, so goes now to the supplier of the drug. So here is where well-intentioned pharmacists might find themselves in problems. Here is where your bush doctor may find themselves in problem. Here is where somebody who sells surgical equipment may find themselves in problems if they decide to help somebody to procure an abortion. So let us look again under Section 73. Who can be charged? Again, we come back to it, the pregnant woman. Or let me not say pregnant woman, the pregnant female, because she may not be at her age, she may not be a woman. So the pregnant female who seeks to procure her own miscarriage can be charged. And then, who else? Any person, this person can be either male or female, who goes out procuring the drugs, knowing that the drugs are going to be used to cause an abortion. That person can be arrested and charged. What then must the prosecution prove? So say that Madam X is charged under Section 73, and the police have these drugs or medications. One, we need to prove that the substance could actually cause an abortion, which means that we need to get either a doctor or a scientist to come and give evidence about the drug. So I, as a prosecutor, can't just go on Wikipedia or Google and type in the name of the drug. And I say, yes, you know, this drug is commonly used to cause abortions. No, I couldn't get that Google or Wikipedia into evidence. I actually have to call somebody, an expert. So I have to call either a doctor or a scientist to come and give that evidence. So the fact that the drug was used to cause this abortion is proof that it's a noxious substance. And especially for the aid and abettor or the helper, you have committed the offense once you supply the drug. So from once you hand it over, you don't have to stick around to see her use it. You know? Once you hand it over, the offense is complete. So if I am prosecuting somebody who is supplying the drug, I don't need to move beyond step 3 to prove the offense. Section 73 is different from Section 72 because I can make the case even if the woman is actually not pregnant. She just has to believe herself to be pregnant. So that's a difference between Section 73 and 72. And I also need to prove the guilty mind of the supplier that when they got this drug or when they produced this tool and they gave it to the person, that they knew it was going to be used for an abortion. But because this is a provision aimed mostly at secondary parties, that is the supplier, the helper, the procurer, you will find that the penalty is only 3 years imprisonment with or without hard labor. Madam Moderator, I think I see somebody has raised their hand.
Okay, I am not seeing it.
Moderator.
Oh, yeah. Oh, okay. Yes, I'm seeing it now. Yes. Do you want to say something? Is that Brother Delwyn?
Yes, not saying something. I was asking a question on behalf of a YouTuber.
Right.
Yes.
So it might have come a little late, but I still have to ask it. Is there a statute of limitation on the act of abortion, be it the mother, medical officer, or persons aiding and abetting?
All right, that's a very good question. In Jamaica, there really is no statute of limitations for major offenses. I mean, you have some traffic offenses which you have to bring within 6 months. You have some curse bad word cases which you have to bring within 6 months. You have, if I decide to take a pan of dirty water and dash it upon you, I have to bring that charge within 6 months. But something like abortion, it can be brought in at any time. So even if you sit down on the evidence for 20 years and it surfaces to light, it comes to light, you can bring the case. So there's no statute of limitations in Jamaica that touches and concerns abortion. All right. Although I was burned with the first one, I'm going to put another case study and see if I can engender greater participation now. So I want to bring to you the case of Deborah Darnell, and it's my usual disclaimer. These are names that I have made up. So I'm hoping I'm causing no offense to anybody who may be in the online audience who has these names or is related or knows anybody with these names. So let me read. Deborah Darnell is a 15-year-old student of William Zard High School. Her mother, Hila Simon, is an attendant at the neighboring army base. Deborah usually walks through the army base as it is a shortcut to her school. On walking past the Patton Barracks, she usually has to endure the unwanted attentions of Lance Corporal Harley Braddock, who always walks beside her, makes salacious suggestions, and touches her inappropriately. On this particular day, when Deborah was walking past, Lance Corporal Braddock grabbed her and dragged her into nearby bushes, saying, "Girl, you're going like you're too good. I'm gonna make you feel something today." Despite her struggles, she was brutally raped. Braddock was actually caught in the act by his colleagues, and he was arrested and charged. He pleaded guilty and was sentenced to 15 years imprisonment. Deborah missed her period. She tried to hide her pregnancy, but could not hide her growing stomach. Eventually, the pregnancy was discovered. Deborah became depressed and her behavior became erratic. The community began to call her mad gal. Hila took Deborah to the Edward Eyre Memorial Hospital to see if something could be done about the pregnancy. But Hila and Deborah were sent away, being told, she might be carrying a future prime minister. Hila and Deborah then went to the Blessed Mother's Maternity Hospital, a Christian institution, where they were seen by the leading obstetrician, Professor Garland Maxwell, who, after a physical and psychological assessment of Deborah, agreed to perform the abortion, which he did. 2 weeks later, Professor Maxwell was arrested and charged for using an instrument to procure a miscarriage. Case has come to trial. The jury is to render its verdict. You are on the jury, members of my audience. What is your verdict? Let me take the first 3 on Zoom and the first 3 on YouTube who respond. You are on the jury. What is your verdict?
Please raise your hand.
Anybody? Yoo-hoo. Anybody?
Sorry,
Yes.
Mr. Taylor, is the physician, Professor Maxwell, did he know that he was doing something illegal?
No, Ms. Watson, I'm not adding any other facts to it. You have to deal with the facts as you have them. Assume that this is the evidence that you heard in court, and you are to render a verdict as to whether Mr. Maxwell is guilty or not guilty. What would be your verdict?
We have somebody with a raised hand, Miss Kamika Duncan.
Yes. Yes,
Hello,
Miss
good night.
Duncan Pottinger. Yes.
Yes, good night. Boy, this one is a pickle, eh? I would say, of course, Professor Maxwell would be guilty based on the laws that pertain at that time, but guilty with explanation because he's trying to.
Oh man, jurors don't get to do that. It's either you're guilty or you're
Guilty
not.
and not guilty. Guilty with explanation. Man.
There's no guilty with explanation. You either have to convict him or you have to acquit him.
Oh, it's sad, but based on the laws that pertain, yeah, he'll be guilty based on the laws that pertain.
All right, so you would go with the straight law and say he's guilty. Anybody else?
Yeah. what a lenient sentence.
No man, jurors don't decide sentence, you know, it's a judge.
Oh dear.
So we have one person would vote that Professor Maxwell is guilty. Deacon Pauline Watson, you want to say what your verdict would have been?
I think guilty too. I think, yeah, he would have been aware that he was doing something that is against the law of the land.
Mm-hmm. So you would go with the law too. Anybody else? Anybody on YouTube? Or anybody want to say what their verdict would be? I see Miss Ralston has raised her hand. Yes, Miss Ralston, go ahead.
Oh. Nobody's hearing me.
I'm hearing
Yes.
you.
Oh, you're hearing me?
Yes.
Okay. As a juror, I would say not guilty.
And why would you say not guilty?
Because of the fact that this is a child, there are other adverse situations, and this not only pushed the child into depression, but because depression can lead to other things. So it's affecting the child mentally and ultimately could be affecting the child physically too. It is also detrimental for the mother. And I think my reason for saying not guilty is because I think that the medical professional, the doctor, was looking at all of these in assisting the child, because this is a child.
Okay. Yes, Boulevard Baptist, that's your hand raised.
Good night again. So these are responses, 2 responses thus far from the YouTube.
Mm-hmm.
Sandra Peter Harvey, based on the law, guilty. Brian Johnson,
Yes.
not guilty due to extenuating circumstances. Do no harm to the mother's mental health. Those are the 2 responses on the YouTube.
All right, thank you very much. I see Miss Pottinger has raised her hand again.
I just want to chime in just one little point in terms of the doctors. They also take an oath not to do any harm. So to knowingly, carry out a procedure that they know will end a life is also against that oath.
All right, it's very interesting, because it seems that I have a hung jury here. I don't have a clear majority, which 7 jurors would have tried this case. I don't have a 5-2 to say, well, boy, 5-2 guilty or 5-2 not guilty. So it seems that I have a hung jury. And it seems then that cases, when we speak absolutely about this issue, abortion, are not as clear-cut as they might seem. So much more of this is going to be addressed in part 2 when we look at these issues now about the extenuating circumstances, the rape, the depression, and so on. So that was a nice one. I'm glad for the participation. So let us come to the defenses, and I decided to give you the case before I gave you the defenses that the good doctor could have. So the only defense for an abortion in Jamaica, that it must be done in good faith for the preservation of the health of the mother. And health here includes mental health. So remember, I said that in the previous, in the case study that I gave you, that Dr. Maxwell had actually done both a physical and psychological assessment of Deborah Darnell. And remember, I said that based on the rape and the pregnancy, she had become, her behavior had become erratic, and her community where she lived began to call her mad girl. So there is that aspect. A doctor could say in good faith. And I must tell you that I think this defense is one such why you don't see many doctors before the courts, because many of them, and usually you find that there's collusion between parent and doctor, can come and say, well, you know, I acted in good faith, I acted to preserve the health of the child or the health of the mother if it's an adult. The second one, the second defense is that only members of the medical profession can properly do such an operation. So a doctor, it has to be a doctor acting in good faith. So all three are linked, you know, you can't take, all these defenses are linked. You cannot separate them from each other. Must be a member of the medical profession, and that medical profession must be acting in good faith. So that's the only way a doctor or a nurse can get around the charge of procuring an abortion. So these are the few. So you see that the defenses are limited in that respect. Secondly, any case of abortion that is prosecuted will turn upon what does the word unlawfully in section 72 and 73 mean. And then you will have to look at the factual circumstances to see if the doctor acted unlawfully, or if the mother acted unlawfully, or if the pregnant woman acted unlawfully. And what does it do? We come back to good faith. So when I am prosecuting this case, as a serving member of the office of the DPP in Jamaica, if I am prosecuting this case, I need to be able to show the jury that this doctor, this pregnant woman, this mother who's helping her daughter get the abortion was not acting in good faith. We have no record to show that the health of this child was threatened. We have no record to show that the mental health of this child was undergoing stress or was threatened. All we know is that she's pregnant and they want to get rid of it. So this is the kind of case I would have to make out to both the judge and the jury, while defense counsel is going to say, no, this doctor acted in good faith, and it may even require the production of medical records of the patient. So then, we come to this nice document that we've had since 1962 called the Constitution of Jamaica. That document, which gives you your fundamental rights and freedoms. So, as many of you are aware, and I'm assuming that you are all aware, that the Constitution was amended in 2011 with the passage of what is called the Charter of Rights. If any of you have not yet read your Charter of Fundamental Rights and Freedoms, go to Google, type it in, and it will lead you to the Ministry of Justice site where you can download it. Every Jamaican must read it. Every Jamaican must be familiar with its provisions. Every Jamaican ought to know their rights under the law. So that's my little plug, saying when this presentation is ended, go and download it. But I want to bring to you a particular provision in the Charter of Rights, and which explains why you may see certain things happening in the rest of the Caribbean, but it has not happened in Jamaica. For example, the laws touching and concerning buggery, and one day you should get somebody to come to your Bible study and deal with all the convoluted law and so on in relation to that. But what the law has in section 1312 is what is called a savings law clause. And what does that mean? It says that all laws that were in existence before the Constitution came into effect are saved. So what does that mean? So whereas you've perhaps seen in St. Kitts where they have managed to they managed to legalize buggery over there by use of a court case because St. Kitts did not have the savings law clause in their constitution. So in Jamaica, you really would require a constitutional amendment to change the law, or you have to repeal the old law and reenact it as a new law, and that gets around the savings law clause. But Section 1312 says, nothing contained in or done under the authority immediately before the commencement of the Charter of Fundamental Rights and Freedoms relating to sexual offenses, obscene publications, or offenses regarding the life of the unborn shall be inconsistent with or in contravention of the provisions of this chapter. What that law says is that you can't come to say that your constitutional rights are being violated because of Section 72 and 73. The law says no. We don't think that is the Constitution. We don't think that it is inconsistent with the rights that you are being guaranteed. So it's either Section 72 or 73 will have to be outrightly repealed by Parliament, or you will have to amend the Constitution to make sure that Section 72 and 73 would be covered by it. And again, you will also see these provisions in Section 26, I think, of the Jamaica Constitution, Order and Council. So, I think I am coming close to the end of this presentation. In summary, the law of abortion has 5 distinct features. The first is, there are no expressly legally prescribed exceptions in the statute as to when an abortion can be done, such as incest or health of the mother. If you go back to Section 72 and 73, if you don't mind me going back. See Section 73, take a quick read. You notice you don't see anything about any exceptions, or you don't see anything about good faith, or you don't see anything about the health of the mother. And if I go back, if you go to Section 72, you will also see that. So really, that aspect of good faith and interpretation of the meaning of the word unlawful is really judge-made law. It is how judges have interpreted the meaning of the acts. It's really the judges that have carved out these exceptions, not Parliament. So that's the first. There are no legally prescribed exceptions. And when we come to look at part 2, we will see how the Jamaican public feels whether or not you should have legally prescribed exceptions. The second, and very important, there are no guidelines as to how old the fetus has to be before an abortion can be done. There is no legal period of what, and I hope I'm using this term correctly, gestational viability. None at all. So if you go back to Roe v. Wade, and if you go back to other countries, you will see that they have 24 weeks or so on. They have a period in which it is legally possible to do an abortion. If you go outside that period, well, you're committing an offense. Jamaica does not have that. And perhaps there is a view that it should have that if you are in favor of abortion. If you are not, well, the law is okay as it is already. 3, a child cannot consent to an abortion. And you may be saying, well, everybody knows that children can't consent to anything, but I wish to bring to your attention Section 8 of the Law Reform Age of Majority Act, which says that where a minor has attained the age of 16 years And in respect of any surgical, medical, or dental treatment, that child can give consent, and the doctor does not need the consent of any parent or guardian or adult. So abortion is an exception to this provision in the law. Some of you may be learning about this for the first time. So God forbid that you should have a child among the membership of Boulevard Baptist Church who decides, you know, I want to look like Rihanna, just to choose a name out of the block, and I am saving up money for plastic surgery. And, you know, she is 16 and she save up the money and she approaches a doctor. Technically, doctor don't have to say anything to you as a parent or the guardian, you know, a wise doctor will. But even then, doctor don't need to get parental consent before they do anything. Once the child is of age and the doctor has satisfied himself that the child is indeed of age 16, does not need parental consent at all. So abortion is an exception to that. In fact, no one in Jamaica can consent to an abortion. Before I move on to the other two factors, anybody want to comment on any of these features of the law in Jamaica before I move on, especially number 3 in relation to the child? Some of you may be just discovering that a 16-year-old can make medical decisions without any parental consent at all.
I think there are too many inconsistencies with our laws. At 16, a child can give consent for sex. Yet that child legally, based on the ILO laws, should not be working. Also, that child cannot vote and legally should not be operating a motor vehicle. So you wonder, how is it that you allow, that the laws are allowing someone to consent to have sexual intercourse that can result in the production of a life, yet legally this person is not able to work, is not able legally to drive a motor vehicle. So I don't know. I really think that there needs to be some kind of, what's the word I'm trying to find? Maybe synchronizing is not the strongest word, but there needs to be some kind of congruence with the different laws, particularly, you know, when you're looking at what happens, a serious thing like giving consent for sexual intercourse at age 16. This person cannot even go into a bar legally to drink. So what is happening here?
Well, we now have a new Minister of Legal and Constitutional Affairs, and her remit is to ensure that the laws are reformed. So the good members of Boulevard think that the laws touching and concerning children need to be in harmony with each other, which I think is actually a good thing, that they need to be harmonized. It's probably time that you begin to agitate in relation to the minister and her remit. It's interesting because the law does say, yes, you can have consent. You can give consent to have sexual intercourse. And then the law locks in the pregnancy by saying, well, you know, if you get pregnant, you know, unless it's going to endanger your health, either physically or mentally, you have to carry the pregnancy to term. So all these things. And if I may just throw in one other shocker, you know that at age 17 in Jamaica, you can legally own a gun. But anyway, I move on. 4, and this is of interest to the men in the audience. Father or spouse has no rights before that child is born. So the law in Jamaica and elsewhere recognizes fatherhood begins at birth, not before. Can't invoke fatherhood rights legally before that child is born. And that has been tested in other countries where men have tried to stop women from getting abortions. And the courts consistently, through these jurisdictions in the United States, in Canada, in Great Britain, in Australia, have held fatherhood begins at birth. You have no rights before birth. So that is one thing, and it's perhaps something that maybe if you are looking at the law of abortion and you are going to think about reforming it or so on, it's probably an issue that may have to be considered in an age of gender equality. Can such an issue touching and concerning pregnancy be left entirely up to the woman, or is it to preserve the woman's sovereignty over her body, that the man ought not to have any decision-making powers over what the woman does with her body? All of these are issues that may have to be considered. And finally, there are no restrictions, if any, as to what methods of abortion are legally permissible. So again, let us say the doctor is acting in good faith. There's nothing to say, well, you can't use that method, or, this method could be seen as cruel and inhuman or inhumane. That method would, no, the doctor is guided entirely by his professional competence and his professional knowledge. So, ladies and gentlemen of Boulevard Baptist Church, I have come to the end of part 1, and I'm open for any comments or questions that you may wish to make.
Yes, just curious to find out how often the DPP receive these cases of abortion.
Not very often. I had earlier said that I've been to the DPP since 2004, and in my time, I've only seen 2. And that's just me seeing 2. There may have actually been more, but I've only become personally aware of only 2 matters.
Is there any special circumstances where it was brought, reached the police and came to the DPP?
Well, the 2 cases that I recall dealt with teenage girls who did an abortion, and they ended up having to go to the hospital to clean up the mess. It's really, when you read the file, that is really what it amounted to. One of those girls was unable, that removed her womb, so she'll never have children again in her life. But because of the injuries that have been occasioned by the abortion, I mean, I tend to have a view that, the backstreet and abortionist in Jamaica is a myth. I think many of the abortions in Jamaica are done by doctors who have invested in equipment but have not trained themselves in how to do it. And you go to a doctor's surgery, and when things go bad, it is a public hospital then that has to clean up that doctor's mess. But there's an unspoken agreement that you don't call the name of the doctor. So all you know is that, boy, the girl went somewhere, and as I have seen in at least one, when I was a clerk of court, not at the DPP's office, when the case came to preliminary inquiry and the girl was to point out the doctor, she looked up and she looked down, she looked left, she looked right, she looked at the back of the courtroom, she looked everywhere except where the doctor was sitting in the prisoner's dock, and said she didn't see him. These are the kind of things that happen.
Well, I asked up the frequency because being at KPH and you go to that special unit where, those girls who do the abortion, quite a number of them, but you get the sense that they come get the treatment, spend a few days, and nobody, bring it any further, and that's the end of it.
I do wish to address what is happening up at Victoria Jubilee, but that is going to be in part 2 with a survey that was done by the Abortion Policy Research Group that was set up by then Minister Daly. And when you look at the survey, and when you look at the figures, you may be quite shocked to see actually what is taking place down there. So yes, you're right. As a medical procedure, it is probably not uncommon, but as a legal prosecution, the enforcement of the criminal law, it is quite rare. Any other questions? Any other comments? I'm trying not to go too into next week's presentations.
I'm just wondering, final question about, you had said that when this first, there was a investigation that was done initially that involved nurses and some other service providers, and they determined, I guess it was research, some research that was done, and they determined that they were not going to sign on some document that was coming out of that research. And do you know why they said they were not going to?
It was the Abortion Policy Research Group report. So the final report that was signed, the final report that was going to be presented to Parliament, the one that Minister Spencer presented to Parliament, there were two organizations which did not sign. The Nurses Association of Jamaica did not sign it, and the Jamaica Council of Churches did not sign it. I can't remember why the nurses didn't sign it, but the JCC, the Council of Churches, said they could not sign on behalf of all their member churches because that is something that the member churches would have had to decide on their own, and they can't make the decision for the different denominations. This is why they did not sign. But I can't remember why the nurses didn't sign.
Okay,
but by next week, I'll be able to say.
All right. Thank you.
Mm-hmm.
Okay. So I think doesn't look like we have any other question or comment. So I just really want to thank you, Mr. Taylor, for making, well, this presentation is very thought-provoking. And, you know, I'm sure we are going to go away and think about quite a lot of what you said this evening. I believe that, you know, as Christians, just like what you were just saying recently about what the Council of Churches wouldn't sign on behalf of individual churches, I kind of believe too that in a way, individual Christians have to also go to the Word of God and really determine what it is that they truly believe, having heard the facts that are presented, you know, like how you have tonight. So I really think that we have to also be prepared to take a stand for what we believe, not to be judgmental, but to take a stand for what we believe. And, you know, so I'm just saying that there's much for us to think about. I see that Reverend Vic has his hand up, so I'm going to ask him to speak now. You're muted.
Thank you, Deacon Bowling. Just to say that underscore the thanks to our brother Jeremy Taylor, and to say perhaps the first case study that he had, we could see it as homework and go and reflect on it and to see whether we would agree with the mother or the father for next week as a start. That's it.
Okay. All right, so I think we have come to the end of the evening. So, Pastor, any final word, and would you please do the benediction?
Benediction. The grace of our Lord and Savior Jesus the Christ, the love of God, and the fellowship of the Holy Spirit be with us all, now and forevermore. Amen.
Amen. Good night, everyone. Thank you for coming.
Night. God
Good
bless.
night.
Good night,
See
everyone.
you next
Good
week.
night.
Yes, good night.
And please tell somebody else about it. Invite other persons to come.
Yes. We
Thank
should.
you. Have a good one.
Okay.